legal information is what we're going to provide at this event tonight. It's not the same thing as legal advice. Legal advice is the application of law to an individual's specific circumstances. The general information presented during this public service event is not intended to be construed as legal advice, nor should it be used by any such person attending this event. Any legal question you have regarding the content of this presentation, or more importantly, your legal rights, should be addressed to a duly licensed Florida attorney. About 2.5 million homes have been repossessed since 2005. Another 6.5 million are in foreclosure or may be soon. These numbers are a little bit old because it goes back to October 12, 2010, but from the Bloomberg report, we're pretty close to them. Nearly a quarter of all mortgaged homes are underwater. What is that? That is where the outstanding loan balance exceeds the market value of the home. It's the biggest problem we're facing in the state of Florida today. This is from the National Legal and Policy Center, October of last year. 2 million Floridian mortgage holders are underwater. They owe more than their homes are worth. Are you one of the millions of people facing foreclosure? I hear stories all the time from clients about hardship, job loss. When the real estate collapsed, you know how many people that affected? I get contractors, I get landscapers, I get the people that used to sell them furniture, I get the people that used to set up restaurants in the towns that were popping up. The ripple effect has been devastating to our state. Illness, divorce, excessive credit card debt, any of these things could have prevented you from making your mortgage payments. You're not alone. 1 in 10 mortgages in 100 largest metropolitan areas in the country are seriously delinquent. That means they've missed more than 3 payments and are technically in default on the loan. This is from the Center for Housing Policy, March of 2010. 4th highest number of foreclosures in the country. Half of the homes with mortgages have negative equity. They're underwater. Half of the homes in our state that have mortgages have negative equity in their investment. What is a foreclosure? It's a legal action to force the sale of a home caused by failure to make payments. If you're a homeowner who is currently facing foreclosure, or if you've already been served foreclosure papers, important legal rights are at stake. Most people I speak to, they say, you know, I know I owe somebody money because I haven't been making my payments. So what can I do? I know I'm wrong here. What can I do? Well, Florida is a judicial state. It is not a non-judicial state. When I say judicial state, it means that it doesn't matter if you've been sending your money to someone for 15 years. If that person wants to show up in court and get you out of your home and foreclose upon you, then they're going to have to appear in front of a judge, and they are going to have to provide the proper paperwork that says they are the ones who truly owns that piece of property. Phases of foreclosure here in our state, 30 days late. You're going to receive the standard letter. It will not be very argumentative in terms. It'll say, you haven't sent us the money and we need to get some money. 60 days late, the rhetoric will begin. We haven't received your money, and if we don't get some money, we're going to probably have to refer this to our outside legal department and let them handle it. 90 days late. This is when you receive what is called the notice of default or the acceleration letter. When I say acceleration, it means they're accelerating the terms of the loan. They are calling the note due, every penny. And if you can't pay, they're going to proceed with foreclosure. If you receive a notice of default or an acceleration letter, you can be guaranteed that they have passed your case off to the law firm that works outside and independent of the bank. Now people hear that and they're like, wait a minute, I'm not going to be dealing with the bank at Wells Fargo? I mean, a lawyer with Wells Fargo or a lawyer who works at Bank of America? Absolutely not. You will be working with, actually you won't be working with them at all. They will have hired regional counsel. And if you can even get the attorney on the phone who is handling your foreclosure case, you'll probably be one out of about 100 people who can actually do that. You'll try to call the law firm, and if you can get past a secretary, you'll be doing very, very well. Those attorneys have no interest in speaking with you. They are there to foreclose upon you. They're not paid extra to modify your loan. They're not paid extra to talk to you on the phone. The only time they usually will talk to you is when they're standing in front of a judge and the judge makes them talk to you. If you get this letter, you can be guaranteed the bank is done dealing with you. They'll still talk to you on the phone. They'll still send you things that say, give us money, but you can be guaranteed they have passed it off to a law firm to begin the foreclosure proceedings. Generally speaking, 4 to 8 months after you have quit paying, this is when a foreclosure is begun. The attorneys will make a public notice that they intend to initiate a legal proceeding. It's called a lis pendens. It's a fancy legal term for pending legal action. The lis pendens is filed by the lender. You will get a knock on your door, either from a sheriff or from the process server, and they will hand you a stack of papers. They will not ask you if you understand what is in the stack. They will not ask you if you want to read through the stack. They will ask you who you are, and when you respond in the affirmative, they will ask for a signature, and then they will be on their merry way, and you are officially served. That is the commencement of the lawsuit. Specifically on the complaint, it states you have 20 calendar days to respond to the allegations contained therein. 20 calendar days. You either respond or you don't. Most people in the state of Florida right now, it's between 80 and 90%, they do not respond. Or they do not respond in an adequate legal manner. A response is not, I lost my job and can't afford to pay. That's a reason why you haven't made your payments, but that is not an adequate legal response to the complaint that the bank's attorneys have given you. If you do respond to the complaint in an adequate legal manner, then the lender must go to court to prove their case. You are then entitled to question, among other things, whether or not the lender has the right to foreclose on your home. You have the right to question how much money you actually owe. You have the right to question whether they put forced place insurance on you or added bogus fees or did a number of things that you would expect the bank to stay on the up and up about, and you would be very, very surprised when you see some of the things that they have chosen to do. If you do not respond, and most people do not, or they do not respond in an adequate legal manner, the lender will be awarded what is called the default judgment. It'll be entered by the court. It basically tells the judge that there are no issues in this case, there are no matters in this case at issue, that everything the bank has said is true, and you are left up to the mercy of them. They're going to publish notice of a sale 2 weeks prior to the sale date. An auction will occur. Whoever is in the home will be evicted. The biggest problem and the biggest threat to people facing foreclosure right now, these people tell me, you know what I'm going to do? I'm going to stick my head in the sand and just let it happen. Who cares? I'll just leave the keys and we'll be done with it. Why would I want to do anything else? $400,000 loan, your house right now is worth $150,000. Bank of America takes it from you. And Bank of America puts it up for sale. And Bank of America sells it for $150,000. You've chosen to do nothing. You just let them go ahead and do it. Bank of America can now come after you for what is called a deficiency judgment. The deficiency judgment on that would be $200,000. $250,000, excuse me. It's the difference between what you owe and what they sell it for. They have 5 years to perfect that deficiency judgment against you. They don't have to do it right away. They can wait 5 years. If they perfect it, they have 20 years to collect it from you. The wave that we foresee in the future will be banks foreclosing, waiting a little while till some of the dust settles, going after these deficiency judgments, perfecting them, and then turning around and selling them for 20 to 30 cents on the dollar to these debt collection companies, those weasels that call you on Sunday at dinner time. Those people that make your phone ring off the hook and leave threatening messages and try to bully people into paying. If they're awarded a deficiency judgment, you have to be careful too. They can seize assets and they can garnish wages. So don't think you can hide. You do have options when you're facing foreclosure. A repayment reinstatement plan, forbearance plan. You can try to sell the property, offer what's called a deed in lieu of foreclosure, short sale, bankruptcy. Federal foreclosure help is out there, but I'm not a big fan of it. Loan modification and fighting your foreclosure. I think if everybody could afford to reinstate the loan, they would not have taken time out of their Thursday evening to listen to my speech here at the Hampton Inn. That said, at any time throughout the course of a foreclosure, you can come clean and pay what you owe, and everything goes away. And everybody's happy, and everything's back to normal. If you are in the fortunate situation where you can do that, you want to make sure when you speak to the lender that you get in writing, down to the penny, what it is that you owe. Never take anybody's word over the telephone. Never. Anything they relay to you has to be in writing. Otherwise, it's your word against theirs. And why is that a problem? Hey, David, if they were off a few $1,000s, why would that be a problem? Because as soon as you sent in that lower amount, you would still be in default on the loan, technically. You would still be in default. You want to be very careful. Forbearance program. What is this? It's a temporary agreement with the lender that allows delayed payments for a limited period of time. And that's the key component of a forbearance program. Limited period of time. Generally speaking, these forbearance programs are going to last about 9 to 12 months. There are not a lot of people I deal with on a day-to-day basis that are going to become economically healthy in 9 to 12 months. You're basically putting off your headache for another day. It may be beneficial at some point to some people, but you're going to be right back in that sinking ship that you were in. They're not going to forgive any of the loan through a forbearance program. They're going to put it all on the back end. They're not going to reach out and try to help anybody that can't prove to them that they can pay either. So if you're going through a bad time, unemployed, they will not give you a forbearance program. You still have to prove that you'll be able to make the payments. Of course, skip payments are added to the loan balance on the back end. You could try to sell the property on the open market. A lot of challenges for people trying to sell property in our state. A lot of challenges. Real estate conditions are terrible. Huge inventory of homes. Buyer financing still very, very limited. And of course, most Florida homes are upside down in equity. Why is somebody going to buy something that's flipped upside down so bad? A deed in lieu of foreclosure. What is this? This is when the homeowner voluntarily conveys title to the property to the lender. A deed in lieu is when you communicate with your lender and you say, I'm not going to fight you on this. We won't fight you. Let me offer you the deed. I'll sign it over. I won't make you go through a protracted court battle, and we'll call this done. It can be beneficial for some people if you make sure there is no deficiency judgment attached to that agreement. If you're just going to sign it over and say, I'm not going to put up a fight and still have the potential for a deficiency judgment against you, it's not a good deal for you. Then you're just leaving yourself open for 5 years for them to come after you for that money that you still owe. If you're going to do a deed in lieu as well, you want to make sure you consult with your tax preparer or your CPA. It could be a taxable event for you if it's forgiven debt. So you want to be very, very careful and understand the ramifications and the consequences associated with a deed in lieu of foreclosure. Oh, short sale. What's that? I'm sure most people have heard. It's when the lender agrees to accept less than what is owed on the property to satisfy the lien. Still some of the same problems, lack of qualified buyers, tax consequences. This should say lenders are unresponsive to people looking to conduct a short sale. It's estimated only 10% of attempted short sales are approved. Why is that? Because usually the conversation goes something like this. This is David. I'm trying to get my representative over at Chase. I've got somebody here to buy the house, and he's actually made a pretty good offer to me. I got to get somebody on the phone at Chase that can give me the green light to let me sell this thing to these people. Okay, Mr. Hicks, we'll get back to you. And 1 week goes by, and 2 weeks go by, and 3 weeks go by, and now you're calling up every single day, sitting on the phone for 2 hours with some customer service rep who never even gets you to the assistant vice president who still can't make the decision. And what's happened? That person who showed up to buy that house has walked. And they've walked around the corner and they bought your neighbor's house or somebody down the block. Because in this real estate market, people are not sitting around to wait for you to haggle it out with your bank about what they are and what they're not going to accept. One of the more unique aspects we see going on right now with people who have been through foreclosure and attempt to short sale their property, title companies are sometimes refusing to insure the sale. Why would they do that? What does a title company do? Title companies guarantee that when David sells a piece of property to Jim, that David had the title free and clear, and that when he's passing it on to Jim, he's passing on a free and clear title. Title companies pay big money into their insurance to guarantee that that is true and accurate. If it's found out not to be, they lose that money. So there's some title companies now who are saying, we're not really sure who owns the property. We're not going to insure that sale because there is still some question in our mind about whether or not the person selling it actually has the legal right to do so. Usually the only person I see that benefits from short sales is the people who are fortunate enough to pick up the house. Bankruptcy, this is what we call the nuclear option. This is when you've exhausted all avenues in foreclosure defense. Chapter 13, reorganization. Chapter 7, total liquidation. Federal foreclosure help, there is some out there. We're going to talk about just a couple programs tonight. I'm not a big fan of it, probably because it really hasn't helped people. HAMP, maybe you've heard of that. It's called the Home Affordable Modification Program. It was designed to help struggling homeowners avoid foreclosure by modifying loans to levels that are affordable. A lot of challenges associated with the HAMP program. One of the more unique aspects of HAMP, you have to be delinquent on your mortgage in order to qualify. So in other words, if you've been quote unquote responsible